And yes, about the facts of the case regarding the applicant, right? Yes, it's that we have 6 learners who, in this case, are the applicants who have been suspended for contra or going against the school's code of conduct, which is the use of cell phones, whether on or off on school premises, shall at all times be prohibited. These learners were searched upon an act that occurred at school when Swiss phone fell in class, and then they took it upon themselves to order an immediate search so that they could prove that indeed learners are violating section 4 of the school's code of conduct. And as the applicants, we are to argue that this search did violate the learner's right to privacy in terms of section 14 of the Constitution. Secondly, they were suspended. Secondly, they were suspended for this act, the contravention of the school's code of conduct. We ought to argue that the suspension was a violation to their basic education. And lastly, as we all know, they protested outside the school premises, which was not once, not twice, but it was 3 times. Therefore, we had to argue that this peaceful protest, or instead a protest, was justifiable, for they had to voice out their concerns about their unfair situation.
Okay. Thank you very much for that. So to give you guys an idea of how I want the session to work, I want to break it up into 3 parts. The first part is on what I think the key elements of mooting are, and how you should think about it going into every mooting round. The second then is the practical aspect of that, how to speak, what are the practical things you should do, so that what you think about moot is also what happens in the courtroom. And then the final part of the session is I want you guys then to moot, to make these arguments on the applicant. And then we can discuss your arguments as well. Does that sound good?
Yes, we are fine with that.
All right. And I also think an introduction is in order, one that's a little bit more detailed than the one I gave earlier. And so, like I said, my name is Kyle Kluter. I'm at Tux at the moment in my 4th year, and I've been mooting for the past 4 years in various competitions. I never got to do schools moot myself. I never knew about it until I got to university, but I was involved as a part of the coaching team for the 2018-2019 team that went to Poland and won in Poland, representing South Africa. So that's just a bit about me, and I'm really looking forward to working with you guys. I think just from your brief introductions, it seems like you guys are really good speakers and have a lot of potential. So I'm really excited about that. Okay, so like I said, we're going to have 3 parts of this moot, and they're going to become more and more specific. And I'll also allow time for questions in between the 3 sessions, and also a bit of a time for a break so that you guys can think on it and also just remain energized for this session. Okay, so but getting straight into it, the first thing I do with a moot is understanding how to think about it, right? And there are 2 parts to thinking about any moot: your case and the goal you want to reach. So like you said, you are arguing about the protest and about the privacy and violation of basic education. At the end of your pleadings, as you go and sit down, you want the courts to agree with you. You want them to think the applicant is right, the respondent is wrong, and we should follow what the applicant is saying, right? But you are also dealing with people at the end of the day. And people are convinced by what sounds good and what looks good. And I want you guys to remember that. The other side of it is then building a relationship with the judges, which is especially difficult online. You can't really build as much of a relationship through Zoom, right? But there are still ways to go about it. And so those are the 2 things I want you guys to keep in mind at all times when mooting, is how do I balance getting what I want with building a relationship with the judges, ensuring that I'm friendly and warm and engaging, that they want to listen to me, and that they are always following along. So the way you do these 2 things is through 3 skills that will sustain your arguments and your entire mooting, right? They are legal research. So what content are you saying? Your the structure of your arguments that you are making, and finally the style that you are using to make these arguments. So what I mean by this is, first, in terms of your structure, is how are you laying out your arguments? How are you think about it almost like a map. You need to show what is going to be on your map, and then you need to stick to that map as you take the judges through your arguments, so that they know where we came from, where we are going, and where we are at the moment. And then the second key part of that, like I said, is your style, and that's what you guys already have a lot of. It's your personal way of presenting. Do you smile when you get asked a question, or maybe the way you use your hands? I don't know. Everyone has their own thing, and I mean, you guys have that, and so we'll just work on developing that, right? But just to show you how specific you can be with it, think about it from the smallest to the biggest things. The smallest being how you're seen on the camera. What is your background? How are you framing it? Do you want them to see your hands or not? Do you do it standing or sitting? So small things like that. What I like about the way you guys have come into this room is both of you are seen in the frame. You guys have good lighting. So small things like that, just to think about, because all of this is a part of the way you are seen, and will contribute to what the judges think of you, and that will help them listen to you, right? And then the final thing I spoke about is the content. And I think you guys already have a good understanding of the content. So the biggest weapon you'll always have, and the thing you'll know the most about more than the judges, is your facts. So always remember that your facts are your biggest weapon. And then what we're going to do is combine your knowledge of the facts with your knowledge of the law, looking at case law and legislation in particular, and then using journal articles where appropriate. But mainly, we're going to use case law and legislation. But yeah, those are the three key things. Just to recap, it's legal research, your style, and your structure. And those are the three things we're going to work on. And that's just the way I see moot and the way I want you guys to think about it when you are trying to get what you want from your arguments and also build a relationship with the judges. So does that make sense? Are there any questions initially?
No, there are no questions.
Okay, perfect. Please just give me 1 minute. I just see I have a voice note from Simon. I just want to listen to that. And then what we'll do now is move to the second part. And now we're going to do a bit more practical work on how to develop those three things. Okay, so I'll be with you guys shortly. All right, we'll begin the second leg in a moment. Just to webcast support, I'm not sure if you can hear me, but we have another team who is trying to log in, and it's telling them that there's a concurrent meeting. I was getting the same message earlier before I was admitted. So I'm not. Perfect. There we go. I can see them now. I think I just needed to be made co-host. So I've just admitted them and hopefully we'll see them in a moment. Thanks so much. All right. Team 15, can you hear me? Team 15, can I please get an indication of whether you can hear me or not? Okay, you are muted. If there are issues on your side, but you can hear me, maybe even just speak in the text chat.
Yes, we can. We can hear you.
Okay, great. Thank you very much. Thanks for joining us, and sorry about the delay. I was also struggling to join the courtroom, but I'm glad to have you guys with us today. So, Team 216, you've been through this, but I think just bear with us. I think let's just start over now that we are all together as a team. All right. So, Team 115, please could you just give me another introduction once again? I know you did it in Court A, but I'd like to know about you each specifically. And also, please can you just, in your introduction, give me a summary of the facts as applicant, and then you can stop there.
You're saying I must just give you the summary of it's something like saying our names, the will come from.
So yes, I am asking that you can say your names and just give me a summary of the facts as the applicant, because that's the side we'll be training and preparing for tomorrow. Please, can you also just try and speak again? The audio is not very clear. We might need to just switch off our cameras and try that as well. But if you could just try again, let's just see if it will sort itself out.
We are team 115 and we go to Makelama High School. So we're taking a case where a school had a very low pass rate and the school had no very so the principal came to the school, Ms. Kola, and started changing rules, including section 4 of the school code of conduct, which stipulated that if any owner is found in possession of a cell phone, the cell phone may be confiscated.
Team 115, I'm struggling to hear you still, hey? Is there anything you can do just to try and help your signal? I just don't want you guys to be disadvantaged. I just want to hear you guys properly.
Recording stopped. Recording in progress.
Can you guys hear me? Okay, team 115, I'm not sure if you can hear me, but I think let's do the following. Your signal seems to be struggling a little bit at the moment. If you guys can just see if you can do anything to improve it, that would be great. If not, it's okay. We'll find another way so that I can hear you guys. And instead, what I'll do then is I'll carry the session on and speak through what we're going to do. And when it's time for you guys to speak again, then we can test it again. Can I just get an indication that you can hear me? Okay. Thank you. I'm just going to mute you for the time being also. So then there are two initial things from my side. An introduction on who I am, and then just outlining what the session is going to cover. I also see that there's someone else who's joined us. Could you please just unmute and indicate who you are in relation to the session?
Yes, Mr. Carl, this is team 115. We have changed the devices because we are having connectivity problems with the other one.
Okay, that's perfect. Well done. You sound a lot clearer. That's great. So I think let's use this device that you've just joined now. You can leave the session on your other device if you'd like as well. Perfect. Great. I'm glad that we can all hear each other. I'm going to begin the session now, and then we can proceed. So you don't have to carry on. I'm happy with your introduction, and we'll revisit the summary of the facts later on. Okay. All right. I'm just going to mute you. Okay, you've muted yourself for the time being. All right. So then, without any other delays, I am Kyle Kluter, as I said in the session earlier, and I'll be coaching you this morning. So I'm a fourth-year law student at the University of Pretoria, and I've been mooting since my first year. When I was in school, I didn't even know about it. I'm a little bit jealous of you guys that get to do this competition. I was, however, involved as a coach for National Schools Moot in the 2018-2019 edition of the competition. I coached the South African team as one of the coaches, and they went on to win the competition in Poland. I'm really excited for this group of students. You guys seem like you have a lot of talent, and I'm really excited. So just to give you an idea of how the session is going to be structured, we are going to have three portions to it. First, an introduction to how to think and approach moot, think about and approach moot. Second, how to practically apply those skills in relation to our case, where we are going to work together and speak about the case. And third and finally, then you guys will moot and present, and we'll get an understanding of how you guys are doing, and then I'll give you some feedback and also make a decision on who the two speakers should be. To that end, just as a point of departure, I'd like to ask both teams, is there one speaker in each team that's more comfortable speaking, and you guys would like that to be considered, or do you want to all be considered and then I'll just give my advice and opinion to the national coach?
Well, both of us are comfortable with speaking.
Okay, great. And can I get the other team's indication as well? I'm not sure who, you know.
If both of us are comfortable too.
Okay, great. Thank you. I'll take that into account. I'm glad. I think we have 4 good speakers to consider then. Okay, so in turning to our first leg, the question that I ask is, what is mooting and how should you think about it when you start a competition? And for me, the way you think about it is that there are 2 things that you must keep in mind. First is your objective, the conclusion you want to reach. And so in the conclusion in this case is, we want as applicant for the court to agree with us that the Code of Conduct, Section 4, violates the children's rights, and second, that the protest was peaceful and lawful, right? So that's the conclusion we are reaching, and that's what we are going to fight to get. We want the judges to agree with us and to rule in our favor. The second thing, though, is that judges are people like everyone else, and they are convinced by what sounds good and what looks good. And so what I want you guys to keep in mind is that you are talking to people, and that besides anything else, moot is a conversation. It is a conversation that you have with judges, and you are trying to convince them and persuade them, but they are still people that are not out to get you. And so you should be professional and formal, but also friendly and persuasive. So then the question is, how do we get there? How do we get to both of those things? And so the way you get there is through 3 things, the 3 skills that you guys use to moot. And I'm sure you guys are more than familiar with this already, but they are your legal research, structure of your arguments, and your style and how you speak. With legal research, what I mean by that is, what content are you using? Where are you getting that content? Are you using magazine articles, or are you using case law and legislation? So we're going to focus on finding the right sources and also understanding how those sources relate and are relevant to our case. So for example, we are going to use Section 28 of the Constitution, which is the best interest of the children. But how does that relate to this case? It relates because it is not in the best interest for the children to be suspended for something that should not be a crime. So that's an example just on how we can use our legal research. Secondly, then, is structure. How are you structuring your arguments? We'll practice a structure that you can use for all your arguments. That includes your facts, the law that you are using, the application, like I said, and finally a conclusion. And how that structure will help you is it will ensure that the judges always know what you are talking about and what you want to go to. So it'll keep them in the loop at all times so they aren't confused about what you're speaking about, okay? And finally is your style. Your style is everything that is personal to you. Do you use your hands? What facial expressions do you make? What words are you using? It also is not just the verbal parts of your mooting, it's the non-verbal stuff. So what are you wearing? What is the lighting or background of your Zoom screen? And so I want you guys to think about that as well. But those are the three things we are going to focus on to help you reach your conclusions and also build a relationship and build a rapport with your judges. All right. So that is the first element. Just to recap, this was how we should look at and think about mood. And the way we do that is through two things. That is our content and the arguments we are making, and also the relationship that you build with the judges. All right. Are there any questions at first from either team? I know team 216, you've heard this twice now. I'm hoping there aren't any questions. But team 115, do you have any questions about any of this before we move on?
No, we don't.
Great. Does it all make sense?
Yes, it does. Thank you.
No problem. Okay, so the next part of the session is going to take up most of it, and that's I want us to work together on the facts that we have, and we're going to apply all of that. So we're going to work on structure and legal research in particular, as well as style, but style will also be focused on when you guys actually argue, right? And so I'd like all of you to have your facts in front of you. And what we are going to do is speak about the arguments that we should make as a team. What are the strongest arguments for prayer 1 and for prayer 2? And how are we going to use the facts to make those arguments? So from each team, what I'd like as a start is just tell me a bit about what you would like to argue. What have you thought about arguing so far? What have you argued in previous rounds? Let's start with prayer 1. And can we start with team 115?
Mr. Kyle, I think your question is, what do we want to argue about? Okay, firstly, we want to argue about Section 4 of the School Code of Conduct being too harsh on learners, as we are in the 4th IR, and also that there was no fair suspension, there was no fair hearing before the learner's suspension, and also that the learners were suspended for a period longer than 1 year, longer than 1 week, I mean. Yes.
From the second speaker, can I please get your opinions? Do you agree with those arguments? Do you have other arguments you think we should make?
Oh, the arguments that the arguments that we want to make is that firstly, that there was no violation of the learner's rights in terms of privacy and basic education. Since
for applicant.
oh, we argued that there was a violation of the learner's rights in terms of privacy and basic education, since the school was not justified in limiting their rights, and so also that the SGP decision violate the learner's rights in terms of Section 17, which is assembly, demonstration, pickets, and petition of the Constitution.
Okay, thank you for that. All right, and then team 216, can I also get your opinion on what arguments we should make?
The question is whether the code of conduct is applicable in the rule of general application and whether it meets the standards set by section 36, subsection 1 of the limitation clause. The issue is also whether the violation of the right to peaceful assembly in terms of section 17, as we should remember that the learners are a minority and therefore should be treated as a minority. Another issue is whether the right to privacy and education are violated by the code of conduct, section 4.
And to the other speaker, do you have anything to add?
Well, yes. According to section 4 of the school's code of conduct, is that the problem is that the effect of this rule, it infringes upon the learner's right to privacy, as it states that everyone has the right to privacy, which includes the right not to have their person or home searched, their property searched, the privacy of their communications infringed, including their possession seized. Therefore, this right is violating, or this code of conduct is actually violating their privacy.
All right. Can both teams please keep their cameras on as well? I think, especially for this next half an hour or so, it's going to be very interactive, and I want us to all work together. Thank you to both teams. I think that I agree with you. I think there's a lot of arguments to be made there. And what we're going to do is we're going to use that as the foundation. And we're going to build up from there, and we're going to make our arguments out of it. So from what I've heard, there are a few relevant things that both teams have highlighted. One, there's an issue of unconstitutionality. We need to look at aspects like violations of certain rights, whether this violation is justified in terms of section 36, which I really like. Second, in terms of privacy, as well as basic education, the impact of both the suspension in terms of the code of conduct, as well as the actual, the act itself of taking away your phone. So two things stood out for me that you guys stated. One is in terms of taking the phones themselves, it's really difficult to do that in the fourth IR. I want to take that a bit further though, right? Because if I stand up in front of a court and I say, listen, we can't do this because of the fourth IR, a judge might say, okay, but the fourth IR is not law. Why should we listen to it? But if I say, today, children often rely on their phones to get a hold of their parents, to do homework, to speak to their teachers. And it forms a key part of their education, and they should have the right to privacy. And you linking it to the Constitution and to legislation, it's a little bit stronger. So I want you guys to think about that as well. Not only what the problem is, because the problem is we live in a world where technology is important, but how that problem relates to law and how we can use laws to show that problem and to argue that problem, right? So to cut a long story short, what I'm saying is the first issue is that taking away cell phones is dangerous and violates privacy and education because of the need for cell phones that that students have. The second problem that you guys highlighted is with the punishment itself. The punishment is really harsh. So let's say even if it was fine to take away a cell phone, to punish someone for more than a week and remove them from education for such a long period, the whole year, that's wrong. That needs to stop, right? Okay, so there are a few issues. I think the three main issues that we've covered are first, the unconstitutionality. And to do that, we need to look at whether it's a justified limitation or whether it violates the Constitution, right? Second is the punishment itself and its impact on education and privacy in terms of the right to cell phones in schools. And third is the punishment, whether it is all right to have such a long suspension. So I think let's build around those three pillars as our arguments. I see there's a raised hand. That's a great idea also going forward. If you have a question, please just raise your hand. Team 216, go for it.
In the facts of the case, there was the first suspension, which was for the rest of the year. And then the second one was for the maximum period. And we all know that South African Schools Act states that the maximum period is actually 7 weeks. So can we still, 7 days. So can we still argue against the maximum period, which was stated in the second suspension period? Because I feel like it's no longer applicable for they actually changed it. So how do we deal with that issue?
Okay, so that's a really good point. I think, but if I'm not mistaken, doesn't it also state, in addition to the maximum period, that it's more than a week, or do they say it's exactly a week?
May you please repeat your question?
The question is, what do the facts say explicitly about it? Do they specify that it is a week, or do they just say the maximum period?
The school governing body calls an agent meeting and decides to suspend for the maximum period the 6 learners who were arrested.
Okay, that's great. The suspension as a right? Okay, a key thing also to note is we shouldn't confuse prayer 1 and prayer 2, because this decision made by the school governing body is to be argued as unconstitutional in relation to the protest after the arrests as well. So we need to just draw a distinction between whether someone was suspended for protesting or for the cell phones, because the cell phones, if I'm not mistaken, are section 4, whereas the protest is the school governing body, which happens later, as you illustrate. So what I would then argue or look at is, in relation to section 4, what was taken, because it wasn't that until the end of the year. And then for the school governing body, that was the maximum period, which was a week, or should be a week at least, in terms of the Schools Act.
Oh, so therefore you're saying that the first suspension was regarding their education and the confiscation of cell phones, and then it was extended for the physical assembly.
Yes, yes. Especially if you read the facts, like you highlighted, an urgent meeting was called and it was decided to suspend. That pertains to prayer 2, if you look at the wording of prayer 2, whereas section 4, which deals with the presence of cell phones in paragraph, there aren't any paragraph numbers, but earlier on at the top of page 2, it only states that their phone may be confiscated and they may be suspended. And the suspension period handed out afterwards to Nsmcc was until the end of the year. Okay, does that make sense? Great. So just to reiterate then, what we have now is we have 3 issues. We have the law itself, the importance of cell phones and its relation to privacy and education, and then the punishment for section 4. Okay, so I'd like to go back to what Team 216 said about general application and section 36. And my question to both teams is, how do we make an argument regarding general application and section 36? How have you argued this in previous rounds? How have you made the argument that section 4 is unconstitutional?
Oh, okay. So the thing is, the question should be asked whether the limitation of the right to privacy by the school's code of conduct actually passes the limitation clause as per section 36.
Okay.
So, okay.
I agree with you, right? And so you'd look at the 5 factors under section 36, the link between the limitation and the right, the importance of the right, the nature of the limitation, etc. But there are 2 things I'd like to add to that analysis. One, I think you guys should look at the Harkson versus Lane case, where they've set out a test for discrimination as well, that you can consider, which is a three-pronged test that looks at whether there is discrimination or differentiation and whether the discrimination is unfair or not. And then the second thing I'd like you guys to look at and to add to this analysis of Section 36 in the Harkson v. Lane, it's Harkson v. Lane, so I'll spell it out for you. It's HARKSEN versus Lane, which is LANE. Obviously, I know that you guys are also presenting tomorrow, so I don't want to overwhelm you. Sorry, just repeat that.
Can I interrupt you? Please repeat the case again.
Sure. Harkson v. Lane, which is Harkson, HARKSEN.
Versus
Lane, which is LANE, like street, lane.
Oh, yes, thank you.
Cool, no stress. Okay. And the second thing I want you to think about is that the law doesn't exist in a vacuum. And so Section 36 and the limitation should be coupled with the Schools Act and other related legislation and case law that looks at similar issues where the court considered whether something was unconstitutional. So, for example, this case deals with corporal punishment as well, and the school removed that already. But there was a case where corporal punishment was considered, and the question was asked, is it unconstitutional or not because of the violation of the children's rights? And so you guys know a lot about this case and these facts. Tell me more in relation to the argument of Section 4 being unconstitutional. What case law is relevant that you have found? Have you guys found any case law?
Mr. Cow, please just repeat your question again.
Is there any case law that is relevant to the first argument, or to the argument that Section 4 should be declared unconstitutional?
Yes, a case law. Do you have any case law? No, on our side we don't, but I'm not too sure. I'll just check and get back to you.
Sure, no problem. Team 216, do you guys have any?
Yes, we do have a case law.
Perfect.
The Western Cape High Court, Cape Provincial Division, as it was then, in the Anton versus governing body, Settlers High School, held that the question should be asked in this regard whether or not the prohibition is aimed at promoting positive discipline and whether or not non-compliance therewith justifies punishment of some other form of sanction. This requires respect, reconciliation, and tolerance. The mutual respect in turn must be directed at understanding and protecting rather than rejecting and infringing the inherent dignity of the offender.
Okay.
Yes, there was another one that asked whether stated that both education and discipline are legitimate goals. However, questions should be asked whether the school's interest should not be considered too broadly. Yes, that way it also
Okay.
is applicable.
You don't remember which case it was?
I'm actually still looking for it.
No problem, no problem. The point I wanted to make is that case law can be really strong and really good here because even if it's not the exact same issue, it could be a similar issue where they declared something unconstitutional because it violates education or privacy or even just the best interests of the child. I don't want you to have to do too much research and change too much, but just as an example to illustrate the point, in the Christian Schools Association versus the MEC for Education, they considered corporal punishment, for example. And in that case, they had to weigh up, on the one hand, the interest of the school and the right also to religion on the one hand, and then on the other hand, the best interest of the child and bodily integrity, and whether the practice was unconstitutional. And so in that case, they found that it was unconstitutional because it violated the best interest of the child and bodily integrity, even though there was the right to religion. But in balancing them, the one lost to the other one. So if you want to go look at that case, for example, and I'll repeat the case in a moment, then you can just go look at how they argued it, how they structured it, to understand how to think about when something gets declared unconstitutional. That may help as well. But just to repeat the case, it was Christian Schools Association versus the Minister of Education. Okay. But let's just take it one step back. And so what we've said is the facts show that there's a provision within the school's code of conduct that allows the school to take away the phones. This should be unconstitutional because of privacy and because of the right to education, right? This is supported by law in terms of the case mentioned by 216. I'm going to ask you to repeat it as well. And also the Constitution in terms of the right to privacy and the right to education. Then what do we do from there? Let's try and put this all together. And I want you guys to apply a structure to your arguments. I'm going to give you a structure that you can apply to all your arguments. Like I said, that will allow you to have a roadmap. And the structure I want you guys to use is called FLAC. So you can write it down, FLAC. I see Simon's joined us as well. How are you doing, Simon?
I'm good, thank you. I'm just going to be here for a bit. You can continue.
Perfect. Just a question, Simon, because we started a bit late, would you advise that I give the team a break at 11 or should we extend the session?
Your call, Kai.
Okay, all right. In that case, we are going to work beyond 11, just so we can finish this session. All right, have all of you written down that acronym, FLAC? Can I proceed?
Yes, you can.
Great. And so the reason why this is useful is because you can use it for all your arguments. And FLAC is an abbreviation and it stands for the... Okay, thanks, Simon. Simon's also just going to give you some tips, but I think let's just conclude this. So FLAC stands for facts, law, application, and conclusion. So in all your arguments, you'll have the facts that you're relying on, the law that's relevant to it, applying the law to the facts, and then concluding. So if we bring together everything that we've done so far, everything that you guys have said about declaring it unconstitutional, the case law you mentioned, as well as the legislation, what would it look like altogether? So I'll do the first one. And then for the two other arguments that we have made, I want you guys to then apply FLAC and then teach it to us. So for this argument, the fact would be that Section 4 of the school's code of conduct allows the school to remove phones from their students, and students will face a suspension for it. That's the fact that's relevant here. The law that is relevant is the Constitution states at sections 14 and 29 that students, and all persons for that matter, have the right to privacy and basic education. And then if we had to apply that law and that fact, what we would say is something like, Section 4, removing cell phones, violates the student's right to privacy and education and should not be allowed. You can also add some case law that we discussed. So we could say, for example, similarly, in the Christian Schools Association case, they declared it unconstitutional for teachers to use corporal punishment because it violates the best interests of the child. And then we can use a conclusion and say, similarly, this court should uphold the best interests of the child as well as the other rights mentioned and declare Section 4 of the Code of Conduct unconstitutional. So can you see how you've put all of it together? We discussed all of that together. You guys gave some law, some facts, I added some, and now we can bring it all together. And so for the rest of the session, we're going to use FLAC to build our arguments for each of the issues that are relevant. Before that, though, I want you guys to just think on that and maybe just write some things down and think of any questions you have. And while you do that, Simon, if you'd like to just give them some advice as well for tomorrow.
Thank you, Kyle. Hi, everyone. I'll basically be giving you some kind of like general tips, so to say, on what the judges are expecting from you tomorrow. I know that I judged probably all of you, and I probably was hectic in my sessions, but I guess, you know, I prepare you for whatever worst you could possibly face in any phase of this competition. So you guys are appearing as applicant, right? Applicant, right?
Yes.
Right. So one thing I say about applicants all the time, and this is just, you know, an offside comment, is a good applicant will also anticipate what the respondent is going to say and preemptively respond to the arguments that the respondent is going to say. That way, you are making the arguments that are to be made by the respondent redundant even before they say them, which means effectively when you have to come back for your rebuttal with your 3 minutes, your 2 minutes, your 1 minute, you don't have to go and address every single thing that the respondent would have said, because you would have addressed most of them preemptively in your own arguments, right? So when you are preparing with Kyle, just, you know, remember once in a while to bring in some preemptive arguments, especially to arguments where you feel very, you know, passionate and strong about, and perhaps even how you should structure your arguments. Put your strongest first, because you might not get the time to finish your arguments. But if we hear your strongest arguments first, we are kind of convinced. So put your strongest arguments first. But anyway, let me give you tips on what your judges are kind of expecting to hear from you tomorrow. I think it's important to remember what your issues are. You are dealing with two critical prayers here. The first question being whether sections 4 of the school's code of conduct violates the right to privacy, and whether the consequences of the suspension violate the right to education. So those are your two critical questions. You are dealing with section 4 and the consequences of section 4 insofar as it relates to, 1, the right to privacy in terms of sections 14, and the right to basic education in terms of sections 29. That's your first prayer. In your second prayer, then you will be assessing the SGB's decision, the suspension, in respect of the right to peaceful assembly, section 17 of the Constitution. So effectively, it's like you've got 3 big questions here. A question about sections 14 of the Constitution, a question about sections 29 of the Constitution, and a question about sections 17 of the Constitution. Those are your areas of focus. These 3 sections, and whether or not these sections have been violated, is exactly what you are trying to answer. So by all means, be sure that whatever you are addressing somehow ties back to one of these sections. It responds to one of these 3 critical questions that you've got. Now, to that end, you will see that then you have to make various arguments for each of these questions. So for example, with respect to your first prayer, where you have a two-legged question, you have to address one, whether sections 4 violates, and in your case, you are indicating that it does violate the right to privacy, others say privacy, however you pronounce it, in sections 14, and that the consequences flowing from the application of section 4 kind of project illegality in the face of the right to basic education, because it gives a sanction that is too harsh to the students. You know, it doesn't consider less restrictive means and so forth in accordance with sections 36 of the Constitution. It has been unjustly unlimited, right? And when you are ventilating these arguments, your starting point is 1, section 14 of the Constitution. What does it say? You would remember I told you yesterday, section 14 is clear. You have got the right to privacy, which includes the right not to have your property searched or your possessions seized. What happened in our case? Their bags were searched, their property was seized. At face value, this is a clear and direct violation of the constitutional provision protecting the right to privacy. So now you must show that that right has been indeed violated. So obviously you'll use your facts, you'll use the law, you'll use case law to support your argument. And when making these arguments, I think it is also important to consider sections 36 broadly, less restrictive means, you know, to say, but really, okay, they violated the school's code of conduct. 1, is the school's code of conduct constitutional? You say, no, it's not, because it violates the right to privacy in terms of section 14, because this is what section 14 says, and the school code of conduct says the opposite. But even if sections 4 was constitutional, was it applied in a manner that is reasonable and justified in an open and democratic society? No. Why? Because the consequences of the application of section 4 are too harsh on the learners, in that, for example, the learners' phones were off, they were not using them, they were not disturbing the learning activities in the school premises, and so forth and so forth and so forth and so forth. And so it cannot be said really that a mobile cell phone, a non-dangerous object that is even off, warrants suspension in any case. There, you can consider different case laws. You consider Antwoni versus SGP, you consider MEC Pillay, you consider all these other cases. I know some of you even had international case law, foreign case law in accordance with sections 39, which is great. You can consider all these things and say, well, you know, when we look at all these things, they tell us that, come on, when there is a breach of a school rule and the potential of that breach to cause substantial disruption to the discipline and the order of the school, then we ought to look at, you know, what sanction, so to say, we can give to the student. But is this breach substantial? There was no disorder that was caused. Discipline and order were still quite, you know, information in the school. The learners, you know, there was no disruption. So is the suspension warranted to all of these learners? No. But moreover and above it all, was the suspension, the procedure to suspend the student, even the proper procedure? That's when you now consider sections 9, I think, if I remember quite well, of the Schools Code of Conduct, not the Schools Code of Conduct, the South African Schools Act, which indicates that they must be given, you know, the opportunity to make representations and whatnot and whatnot and whatnot and whatnot. Was that followed? No, it was not followed in this case. Only Sfiso was given that opportunity, and Sfiso is not even the applicant, so we are not going to consider Sfiso's case. Let's consider the 6 applicants. Were they heard? Did they have a hearing? No, which means there is an irregularity with the suspension of these individuals, because they were never given the opportunity to be heard in their first and even at the reviewed suspension, which means both suspensions are necessarily irregular and they must be set aside. What am I forgetting? Oh, with regards to the protest, then you have to address Section 29, but Section 29 deals specifically with the consequences. Obviously, if they're at home, they are losing education. If they are losing education, you are increasing the chances of them not finishing school on time. There is the Constitutional Court decision, Moko versus the acting principal of Umalusi, that I said you guys must consider yesterday, the day before, whenever I was judging you in any of the sessions, where the court said suspension is a disproportionate measure because it places an unreasonable hold on learners' careers. That's your go-to, decision when you are dealing with the consequences of suspension and whether or not the suspension violates the right to education in your case. And then finally, you have to consider Section 17 and how the SGB's decision to suspend the learners is against Section 17. That's where you rely on the fact that, one, there were no identifiable, culprits at the scene. So we cannot reasonably say that it was the applicant. The applicants were not there. And given the fact that the applicants' future was already at stake as they were suspended, why would the applicants want to, set violence, set buildings on fire, set bins on fire, whereas they know that they are already at stake here? It doesn't seem, anywhere in the facts that it is suggestive that they are willing to take the risk of being expelled. They just want to go back to school. They don't want to be expelled. So it doesn't seem that the facts would suggest that they were actually responsible for the conduct, and that's why the facts are clear that there were no identifiable culprits at any of the scenes. When the bin was bent, there were no identifiable culprits. But even earlier on, when the admin building was bent, there were no identifiable culprits. So why are we placing the applicants at the scene when they were not actually identified at the scene? That's your go-to. And then again, you have this material irregularity on the suspension that they were never had properly. Those are the kind of things that your judges are basically looking to hear from you generally. So best of luck with your training. I've given you some pointers from the perspective of a person who's been with the facts more than you have, from the person who's been with the facts from day one, from the person who drafted your documentation. Those are the things when we are drafting these documents, we are expecting to hear from you. So that's what your judges will be expecting to hear from you broadly. But obviously, judges will think, in many different ways. So there are other questions that will pop up. But I need you to remember that what we just spoke about now will be the main issues that lead to all the other kinds of questions that you receive from your judges. And all the time, remember to be able to bring your judges back to what the facts say are the main issues. So I'm now going to hand over back to Kyle to proceed with the training, and I wish you guys all the best. Kyle, over to you.
Thanks so much, Simon. That was really valuable. And I think just to all of the speakers, the one thing I want you guys to take particular note of is how Simon used the facts to his advantage very strategically. It wasn't just that Section 4 was enacted, it's that students' bags were searched without their permission. It's not just that there's this provision, it's that cell phones don't do harm. And so how can you really punish children? It's not like these are dangerous cell phones. Half of them weren't even on. And so that's one of the biggest things I want you guys to take note of, is that the facts are your greatest weapon. I don't know if every single judge is going to know the facts as well as Simon does, and use that to your advantage. Use the facts strategically, and like Simon said, always bring it back to the facts and also to the way you are representing them. Because you don't want it to seem like the facts show students that want to be expelled and are violent, which I don't even think is necessarily the case. You are showing students who are willing to come back to school, who want to finish their education and have protested peacefully for that right. So that's the big thing I want you guys to keep in mind. And also take note of the structure. I think if you guys can apply that structure like we are going to practice now, it'll be really, really beneficial, because you'll always be able to return safely to your structure, both when answering a question and also when making an argument. So as we jump back into the session, what we did was we looked at the idea of unconstitutionality. and how to make that argument using a few sources: Section 36 of the Constitution, relevant case laws such as Harkson v. Lane, in understanding the standard when making a discrimination and unconstitutionality argument, and then also applying it specifically to the context of discipline, education, and the best interests of the child. So what I want to do next then is look at the second issue that we all agreed upon, and that is Section 4 of the Act, or rather of the Code of Conduct, and the actual action of removing students' cell phones. So I think there are a few different elements to this. So firstly, whether a school should be able to take a cell phone at all. And then secondly, the nature and the implementation of that policy. So how they did it? They searched the bags without any permission. They then suspended the students and those elements. And I want to look at that. The difference this time is I did FLAC for you guys last time, and I chose what was relevant. This time I want you guys to lead it a little bit more. What facts should we use in FLAC? What arguments are we making generally? What law is relevant? So I want to hear from you guys. How would you make an argument about Section 4 as a violation of privacy and education in terms of the specific removal of the phones? You guys are on mute if you are trying to speak.
Okay, so right now I'm just gonna argue using Section 29 of the Constitution of the Republic of South Africa, which is education. So the learners were suspended for a period longer than 1 week, and there was no fair hearing before their suspensions. Section 29 of the Constitution of the Republic of South Africa is education, and it states very well that everyone has the right to receive education in the official language or languages of their own choice at a public educational institution where that education is reasonably practicable. So when the school suspended these learners, they're infringing their right to basic education. And also, if we look at the case between Head of Department, Department of Education, Free State Province versus Welcome High and another, in a similar case where pregnant learners were suspended, that the decision to suspend those learners was unconstitutional. Therefore, Justice Section 4 of the School Code of Conduct is unconstitutional and also invalid.
Before Team 216 speaks about their position, I just want to give some feedback on that. So the things I really like about that is that you had a really strong conclusion. So I like that you brought it back and said, therefore, Section 4 is unconstitutional, especially after you compared it to the Valcom school case. I thought that was really well done. I understood the similarities with with that case and this one, and the impact of suspension. So I think we should keep those elements. What I would like to see more of, though, is less teaching of the law and more arguing of the law and the facts. So, for example, you told me Section 29 deals with education and the right to education in your language, which is great, but it's not relevant to what we're doing today. You can go straight to what is relevant and what is the point that you're trying to get across. Your point is that suspension is unconstitutional and it's extreme. This is shown in case law, and therefore we should also say this is unconstitutional and extreme, right? So I like that, but I think just go straight to the point. And also, I think we need something before that. So I want to keep this, and I like this idea, but I think it's more relevant to grade 2, and I think it's more relevant to the third element that we discussed, which is suspension. For this one, I want more of a focus on privacy and the act of bag searches and the right of a school to search a bag. So think about that, and maybe have a look at your notes and arguments on what you can have on that. But let's also just hear from Team 216 on what they would say.
Mr. Carl, just before team 216 can start, I just wanted to ask if so. You're saying I must just go straight to the point. So it's not really necessary to just state what the law that you used says.
So it is sometimes you need to be strategic about it. So think about it this way, right? Let's say we are using Section 29 to prove that the law applies. We need to show that this is an issue that deals with education, or that we can use Section 29. Then you can explain it. But if you are just using it to outline what it is, I think in this case, the judges will know that it deals with education. So it's not necessary to say what Section 29 is. And also, you spoke about the fact that there's a right to have education in your language. That's not an issue in this case. We aren't dealing with a language issue, as far as I understand. And so we don't need to speak about the right to language and education.
Okay, so can I just, by that, can I just take the only part that is related to the case in the law?
Yes, you can. And so, for example, what's more relevant in terms of education is access to education. So saying suspension means that students are at home and therefore they don't have access. And Section 29 says that a key part of education is access.
Yes. Thank you. Thank you.
No problem. I hope that helps. Okay.
Okay, regarding privacy, I believe that Section 4 of the School's Code of Conduct essentially grants the school power to search bags of all learners at random and without notice or a warning to such learners. The effect of this rule, as stated before, is that it infringes upon the learner's right to privacy, which is a right granted by Section 14 of the Constitution, which involves that they have the right not to have their property searched, including their possessions seized. And we all know that cell phones have become more central, or have increasingly become more central to human lives. They contain calendars and apps that contain sensitive information. Therefore, losing a phone, or worse, having it confiscated, takes away the owner's access to all of this. It takes away from the owner's autonomy and arguably their dignity as well, since privacy is a fundamental right essential to autonomy and serving as the co-foundation upon which human dignity is built. So a code of conduct that violates autonomy, dignity, including privacy, is surely unconstitutional, for dignity cannot be limited, as it is a non-derogable right.
Okay, so what I liked in particular about your submission there is the structure, especially the first half. You started off, like we said, with FLAC. With regard to Section 4, you outline what Section 4 does and what it is, and then the effect of Section 4, which was really well done. And then supporting it with Section 14. I just think you need to just remain consistent throughout, because halfway through you changed your tone a little bit, which I think was, if I'm not mistaken, because you were less prepared on that element than you were the first half. And so what happened was you started off with one tone and then your tone shifted. So you made less eye contact, for example, and your style changed. So the biggest thing is just to remain consistent with it. The way this would have been done, I think, is when you started speaking about the importance of technology to students today, is just remain confident in that, maintain your eye contact. And also just, I think you need to also, similarly, like I said previously, be direct, ensure that you are making the exact point you want. So technology for students today plays a central role, both in terms of their education and their privacy. And I think you must maybe just look for something to support that, maybe a journal article or a statistic on the importance of cell phones today, and then be firm in your conclusion. But I really like that from both teams. And so what we've done is we have two arguments outlined almost. We have the first in terms of the law and how it should be set out with 36 and unconstitutionality. Then we spoke about privacy and why it was wrong for there to be random bag searches without permission. And this is what we all agreed upon. Remember, when we set the foundation, we said that there would be three things. It would be the unconstitutionality of the law and its implementation in terms of bag searches and suspensions. So we've covered those first two elements, the unconstitutionality and the bag searches. And then finally, we have the suspensions. So what I would like to do then is repeat this process, and you guys just need to keep trying to apply FLAC. And I want the speakers who did not speak this time for 115 and 216 to present the final aspect on suspension. So what would your arguments and your position be on suspension, considering legislation, case law, and the facts? And I want you guys to just, like we did for privacy, do the same thing for suspension, and then we are going to take a short break, and then I'll explain what we're going to do after that. All right, so okay, let's start with 216 this time on surveillance. And the speaker did not go. It's your turn.
My Justice, the rights granted in the Bill of Rights are not absolute. They may be limited in terms of Section 36 of the Constitution, otherwise known as the limitation clause, which states that the rights in the Bill of Rights may be limited only in terms of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors, including A, the nature of the right, B, the importance of the purpose of the limitation, C, the nature and extent of the limitation, D, the relation between the limitation and its purpose, and E, less restrictive means to achieve the purpose. Subsection 2 states, except as provided in subsection 1 or in any other provision in the bill, in the Constitution, no law may limit any right entrenched in the Bill of Rights. The question should be asked, does the limitation to the right of privacy by the School of Code of Conduct pass the limitation clause? Firstly, the nature of the right. The nature of the right that is being limited by this rule is directly linked to dignity and autonomy. The importance of the purpose of the limitation. The purpose of the limitation of the right to privacy is to enforce discipline. The nature and the extent of the limitation. The limitation is one that takes away the autonomy and the dignity of the learners, as their cell phones that contain personal and sensitive information which can be taken away. The ability to communicate, make financial transactions and their day, and also do research using internet resources is taken away. The limitation cripples their lives in the modern age. Fourthly, relation between the limitation and its purpose. The aim of the rule is to enforce discipline and to improve the school's metric results. Although the results have improved, the learners who bring their phones to school may choose to keep their phones in their bag but still be able to concentrate in class. But other learners who keep their phones at home may choose not to concentrate in class. This shows that there is no direct link between the limitation. There is no direct link between the confiscation of the cell phone and discipline. Finally, the less restrictive means to achieve purpose. Yes, the school could instead put in place measures to have compulsory morning and afternoon studies. They could impose fines on learners who use their phones during classes instead of confiscation. This just shows that suspension is a bit extreme, as it should be the last resort, not the first resort of a school.
Thank you. Thank you, Council. Can Team 115 also present their position on the suspension?
Okay, so the learners were expelled by the SGB, which does not. The learners were suspended for a period of 1 year. So now they're suspended by the SGB. Now, if we look at section 9 of the South African Schools Act, 84 of 1996, it is suspension and expulsion from the school. Now, its subsection 1 states that subject to any applicable law, the governing body of a public school may, after a fair hearing, suspend the learner from attending a school as a correctional measure for a period not longer than 1 week. And subsection 2 stipulates that a learner can only be expelled from school by the head of the department and if found of serious scale, of misconduct. Now, your justices, the school, the SGB did not have the authority to suspend the learners from the school since they were not the head of department and there was no fair hearing that was conducted before they were suspended. So, your justice, which further points the unconstitutionality of section 4 of the School Code of Conduct.
I actually last time gave feedback before. I'll just give feedback to both speakers. And I see before that there's just a question.
There's this question that I want to raise. It's regarding the actual code of conduct. It states that section 4, the use of cell phones, whether on or off by learners on school premises shall at all times be prohibited. Any learner that is found in possession of a cell phone will have the phone confiscated and may be suspended. The actual school code of conduct does not completely give us a full story on how long the suspension will be. It partly tells us that there may be a suspension, but to what extent will the suspension be? It does not provide in terms of section 8 subsection 5, which states that a code of conduct must contain provisions of due process safeguarding the interests of the learners and any other party involved in a disciplinary proceedings. There is no explanation of whether there will be a disciplinary hearing or any sort of disciplinary proceedings. So should we take that into account when discussing the extremeness of the suspension?
Exactly. And absolutely. Let's say there's a crime, and let's say the crime is speeding, and the government does not tell you how long you'll go to jail. And then you get arrested for speeding and they're like, okay, you'll be arrested for 20 years now. And they just decide. It's a massive problem to not let you know. And what illustrates this problem in particular is that the sentences that, or the, not sentences, the suspensions that they've been giving have been a lot longer than the maximum period. After the phones are found of the 6 owners, they give out a suspension of until the end of the year, which is longer than the 7-day maximum period that you guys pointed out earlier. And so there are 2 problems then. One, there's no due process because there are 2 things lacking. One is the period of the suspension, and 2 is the process of a hearing. They don't actually mention it or give it in practice. And 2 is the implementation then, because it is extreme, it extends the maximum period, and also it is done without hearing the student side of things. So definitely you can attack that. Just in giving feedback then also, I think to the first speaker from 216 regarding suspension, I think you could have just been a bit more direct on suspension. I like the way you've structured that, but I think that argument would be perfect for the first leg that we discussed in terms of the unconstitutionality and applying a Section 36 test. So just think about where it fits into all of the pleadings, because I think that was really good, but I would have just liked a bit more specifically on suspension, like the question you asked regarding whether we should attack both the provision itself and the implementation. I think that's really good. And I think you could just integrate more fact and law when conducting the 36 analysis. So in relation to the nature, SVM states that the nature of a right is this, blah, blah, blah. Paragraph 4 shows that the nature of the right is this. So just being a little bit more integrated and not just having facts or just having law. That would be my advice. But I liked your style, and I thought your legal application was good. To the speaker from 115, I liked some of your argumentation. It was really direct and specific. I think it could just do with a bit more structure on clearly what is the facts, the law. So just working on that structure and improving it. But I really liked the argumentation that you had. I thought it was quite specific and clever on what you brought up. So if there are any questions, do let me know as well. But what I want to do now is have a 10-minute break. We can actually make it 12 minutes, and we can come back at past. I'm not going to go on for too much longer. I know this session was supposed to end at 11, but if you guys are comfortable carrying on, I'd like to do so. And there are a few things I'd like to do for the rest of the day. The first thing is at past, I want you guys to come back with everything that we've done, and I want you guys to put it together. Tomorrow, how much time are you guys afforded to speak?
20 minutes each team.
Each team, 20 minutes. Okay. So what I want then is because this is only one prayer, each speaker is going to be afforded 5 minutes. All 4 of you are going to speak for 5 minutes. And I want you to make arguments on everything that we've discussed. And I want you to apply the things that we've done today. Focusing on applying FLAC and balancing building a relationship with the judge and making your arguments in a compelling way. And also then think about what Simon was saying about making preemptive arguments for the respondent. So you'll have 5 minutes to present prayer 1, and that'll be for all of you. I want to hear all of you speak. And then after that, we can discuss if you guys want to do anything further, because I'd like to teach you how to do rebuttal as well. But we can also discuss if you guys want to call it and you want to be done for the day to go practice and research, that's fine. Otherwise, we can carry on for a little bit longer or take a break and do a bit later. So yeah, we have a 10-minute break now. You guys please return at past and decide amongst your teams who's going to speak first between the 2 of you. And then also I'll decide who's going to speak first amongst the 4 of you, and then we'll go from there. Sound good? Any questions? Okay, I'll take that as a no, and I'll see you.
There are no questions from our side. I just want to say that.
Okay, perfect. Thank you. In that case, then I'll see all of you at past. Cool. Thank you. I don't want to go for too much longer with the session because the team has been going for quite a while, but I do want to just see them present. Okay, that's great. Thank you.
No, it's not.
Are the teams ready?
Yes, the team is ready.
Brilliant. Can all team members also just type their name into the chat as well? Just because I need to give feedback on the session and I just want to keep feedback per team and speaker.
No, we're not. Oh, okay. Are we submitting the same thing, or one of us has to do the first prayer and the second one has to do the second prayer?
No, you guys can all submit the same thing.
Okay.
The point is that we didn't do prayer two all together, and I want all of you to present on prayer one on an equal footing. Because remember, only two speakers will present, and so you presenting prayer one or two within your team won't necessarily be the case going forward.
Okay. What?
Okay. So yes, each speaker has 5 minutes. Since team 216 was here first, you guys can begin.
Okay. My justices, our first submission is regarding the unconstitutionality of Section 4 of the School's Code of Conduct in relation with its infringement to the rights to privacy and basic education. Section 4 of the School's Code of Conduct states that, and I quote, "The use of cell phones, whether on or off, on school premises shall at all times be prohibited. Any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended." Section 4 of the School's Code of Conduct essentially grants the school power to search bags of all learners at random and without notice. The effect of this rule is that it infringes upon the learner's rights to privacy, a right granted by Section 14 of the Constitution. Section 14 of the Constitution states that everyone has the right to privacy, which includes the right not to have their personal home searched, their property searched, their possessions searched, and the privacy of the communications infringed. And we submit that the search conducted
is this not limited, especially on school grounds?
May you please rephrase your question?
My question is privacy absolute? Is it not a justifiable limitation in this instance?
It is a fundamental right, but it is not absolute. This means that it can be limited by Section 36 of the Constitution. And we submit that the search that the school conducted on learners and the confiscation of their cell phones was an infringement to the right granted by Section 14 of the Constitution. Privacy is a right that becomes more intense the closer it moves to the intimate personal sphere of the life of human beings. Cell phones have increasingly become central to human lives. They contain calendars that plan our days, apps that are capable of sharing sensitive information, such as banking information, and apps that track fertility and reproductive details of the user. Losing a cell phone.
Is there any authority for that?
Apps that track fertility and other sexual reproductive of the
I meant more generally in terms of the importance of cell phones to students in particular.
As we all know that we are particularly in the fourth industrial revolution, then yes, it is proof that everyone actually does need technology these days to survive, as we all know. My justices, it takes away the owner's autonomy. This confiscation of the cell phone takes away the owner's autonomy and arguably their dignity as well, a right granted by Section 14 of the Constitution. A rule such as this one that infringes autonomy, dignity, and privacy is surely unconstitutional. My justices, we submit that we remind this honorable court of section 28, subsection 2 of the Constitution, which states that a child's best interest of paramount importance in every matter concerning the child. In this section, or in this section particularly, a child refers to a person who's under the age of 18, and the applicants are all below the age of 18. Not only did the school violate this learner's right to privacy, but they infringed upon their right to basic education in terms of section 29 of the Constitution. My justices, we saw how in this learners were found in possession of a cell phone. They were immediately suspended for the rest of the year. This goes against section 9, subsection 1, paragraph A of the South African Schools Act, which clearly informs us that subject to this act and any applicable provincial law, the governing body of a school may, after a fair hearing, suspend a learner as a correctional measure for a period not longer than 1 week. My justice, this suspension is extreme and the limitation is unreasonable and not justifiable, for they ought to follow the South African Schools Act and make sure that they are not violating the rights in the Constitution. Therefore, they have to keep in mind section 2 concerning the supremacy of the Constitution, which states that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. If it pleases the court, I would now like to take my leave.
One final question, Counsel. What about the students' actions themselves? Were they not violent and aggressive? Should we not also consider that in looking at an appropriate punishment?
Which violation are you referring to, my justice?
I'm speaking to burning the bins, the protests.
My justice, this act came after the suspension, for they found it reasonable to raise their voice, for they were not given a chance to a fair hearing, as it is stated in section 9 of the South African Schools Act.
Thank you, Counsel. That answers my question, and we can hand over to the second speaker.
Okay. My justice, protocols are meant to bring stability and equality for everyone involved. As it was stated in the case of the MEC of Education, KwaZulu-Natal and others versus Pali, that both education and discipline are legitimate goals, but however, care must be taken not to take the school's interest too broadly. Therefore, my justices, I submit to this honorable court that the immediate search cannot be validated as a mere reasonable suspicion for a search to be conducted due to the fact that one learner was found in possession of a cell phone. My justices, it was stated in section 17 of the Constitution that everyone has the right to privacy, which includes the right not to have their property searched, their possessions seized, and etc. My justices, privacy is a fundamental right essential to the autonomy and protection of human dignity, serving as the foundation of other fundamental rights in the Constitution. To bring stability for everyone, as stated in the MEC of Education. My justices, it was proved that Ms. Khoza dealt with the matter of Siso Cele according to his procedure, but did not follow the same procedures in the case of the 6 applicants. My justices.
So, counsel, in that case, the student was suspended until the end of the year. Do you think that was the correct procedure? Are you saying that you are fine with that aspect?
My justice, unlike the applicants, Siso Cele was given an opportunity to a fair hearing, meaning that he was given an opportunity to representation, unlike the applicants who had received no such privilege as stipulated in section 8, subsection 5 of the South African School Act. If it pleases the court. My justices, in terms of section 28, subsection 2 of the Constitution, which states, a child's best interests are of paramount importance in all matters concerning the child. And as stated, that in this section, child means a person under the age of 18. All the applicants are under the age of 18, meaning that the best interest must be taken into acknowledgement when dealing with decisions regarding their future. The violation of their right in terms of Section 4 of the Code of Conduct is not in their best interest, as they were not given a chance to representation and a chance to state the reasons for the possession of a cell phone. My justices, it is stated in Section 9, subsection 1 of the South African School Act, which states that subject to any act or any applicable provincial law, the governing body of a school may, after a fair hearing, and I emphasize, a fair hearing, suspend a learner from attending a school as a correctional measure for the period not longer than a week. The school did not give the period or length of their suspension, but rather the learners were suspended with immediate effect, with no consultation with the representation of the learners. Therefore, this goes way out of protocol, and a law is nothing if proper procedure is not followed.
So, Council, just one final question from my side. Has this court ever declared provision of a code of conduct unconstitutional before?
May you rephrase the question?
I'm just saying, is there any case law we can refer to where this court has taken a code of conduct from a school and stated that a provision is unconstitutional?
Council submits negligence.
What do you mean, Council?
Council does not clearly understand the question.
Would you like me to rephrase it, or perhaps we should move on?
We should move on.
Okay, that's all right, Council. Perhaps you could just conclude in a sentence or two, and then you can take your leave.
We would like to submit that the applicant's rights, namely the right to privacy and to education, as stated in Section 14 and Section 29 of the Constitution, were violated by the school code of conduct, and the school code of conduct is not a rule of general application. Therefore, it should be struck out and deemed unconstitutional by this honorable court. Okay,
thank you, Council. All right. Team 115, if you guys are ready. And please could you also just insert both of your names into the chat. Just for my purposes, I need to give feedback per speaker to the national coach, and I would like your names and surnames for that.
Yes, Mr. Kyle, we will just write our names in the chat box. So we are like presenting the whole thing. We are like presenting our argument now.
Each speaker has 5 minutes just to present prayer 1.
Okay, thank you, Mr. Kyle.
So both of you will present prayer 1. The reason for that is because we've spent the session working on prayer 1, and I want to see each of you just speak. And then I'll give feedback to all speakers on your presentation.
Section 14 and 29. As the court pleases, I am Pili Lenene, and I'm here with my co-counsel, Dutu Wandlela. We're Team 115, and we appear on behalf of the applicant. In this case, there are 6 learners who brought cell phones to school, and they were all suspended. The High Court ruled in favor of the respondent after the case or the learners decided to challenge the school governing body's decision. The question before the court is whether Section 4 of the School Code of Conduct is unconstitutional and violate the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution of the Republic of South Africa.
Recording stop. Recording in progress.
The counsel for the applicant therefore agrees that Section 4 of the School Code of Conduct is unconstitutional and violates the learner's right to privacy and basic education. The learners were suspended for a period longer than 1 week, and there was no fair hearing before their suspension. Section 29 of the Constitution of the Republic of South Africa is
Counsel,
Yes, my Justice.
what would have been a fair hearing? What is the standard for fair hearing?
My Justice, a fair hearing is a hearing where the learners were also given a platform to defend themselves, and also if it happens that they are suspended, be suspended for a maximum period as stated in Section 9 of the South African Schools Act. May I proceed, my Justice?
Please do.
Thank you. Section 29 of the Constitution of the Republic of South Africa is education, and it says that everyone has the right to education. The suspension of these learners from school effectively removes these rights from them and infringes their right to receive education. Section 4 of the School Code of Conduct is also inconsistent with Section 2 of the Constitution of the Republic of South Africa, which stipulates that the Constitution is the supreme law of the Republic, and any law that is inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. It was also decided on this court in the matter between Head of Department of Education, Free State Province versus Welcome High, in a similar case where pregnant learners were suspended, that the decision to suspend those learners was unconstitutional. Also, in the matter between Anthony V. Secklers High School and the school governing body, it further supports the unconstitutionality of the decision. Also, in the matter between MEC of Education, KwaZulu-Natal and others versus Pillay, in a case whereby a respondent was found in breach of the School Code of Conduct by wearing a nose guard. The respondent was then suspended, and it was then decided that the decision to suspend the respondent was unconstitutional. So therefore, justices...
Counsel, with the Pillay decision, isn't there a key difference? Because in that case, the reason for the nose guard was a religious and cultural decision, and not one of just bringing a cell phone to school.
My Justices, yes, it is kind of different, but we must also not forget that the learners may have brought cell phones to school for safety reasons, especially because we cannot ignore the criminalities that in reality occur. May I proceed, my Justice?
You may.
Thank you.
And your time is elapsing, so if you could begin to conclude as well.
Thank you, my Justice. Therefore, Section 4 of the School Code of Conduct is unconstitutional, as the applicant will submit that Section 4 of the School Code of Conduct violates the learner's right to privacy and basic education. If it pleases the court and there are no further questions, I would like to hand over to my co-counsel, Dutu Gondlela.
Cool. Thank you, Counsel. You may do so.
So, as the court pleases, I am Dutu Gondlela, the co-counsel of Pilenene, and I'll be dealing with the second part of our argument. Now, the applicants' bags were searched purposefully and their cell phones were confiscated. The police also read their messages on WhatsApp. Now, Section 14 of the Constitution of the Republic of South Africa is privacy, and it states that everyone has the right to privacy, which includes the right not to have their person or home searched, their possessions seized, and the privacy of their communication infringed. Now, so as the police were searching the learners, they were violating the right to privacy, and also the police had no right to read their messages on WhatsApp, as this was infringing their communications. And also they had no right to confiscate, the school had no right to confiscate their cell phones, as that was seizing their possessions. Now,
so Counsel,
yes.
Why are you bringing this matter against the school and not against the police?
Because Your Justice, thank you for the question. As the court pleases, we submit that it was the principal who gave the authorization of the search of the learners.
Okay.
Yes, Your Justice. Your Justice, also, the learners are suspended for the rest of the year by the SGB, which does not have the authority to expel a learner from the school. They can only suspend a learner for a week and after a fair hearing is conducted. Now, Section 9 of the South African Schools Act 84 of 1993 is suspension and expulsion from the school. Now, its subsection 1 stipulates that, subject to any applicable law, the governing body of a public school may, after a fair hearing, suspend the learner from attending school as a correctional measure for a period not longer than 1 week. And also, its subsection 2 states that a learner can only be expelled from school by the head of department and if found in breach of a serious misconduct. Now, Your Justice, we submit that the school's SGB did not have the authority to expel the learner from the school for the period longer than 1 week, since there was no fair hearing and since they are not the head of department. Now, Your Justice, Section 36, subsection 1, Section 36 is the limitation of rights, and its subsection 1 states that there must be less restrictive measures to achieve the purpose. Now, the school suspension of the learners was harsh as they suspended them for a period longer than 1 week, and there was no proper procedure that was followed during their suspension. There must have been less restrictive measures that should have been taken by the school to achieve the purpose of Section 4 of the School Code of Conduct. Now, this further points to the unconstitutionality and the unfairness of Section 4 of the School Code of Conduct.
So, counsel, just one further question on this point. I understand in terms of Section 36, there needs to be a balancing, but hasn't the school done a great job? I mean, the pass rate has increased drastically and there's finally discipline. For that reason, don't you think we should allow Section 4 of the Code of Conduct to remain?
Your Justice, can you please rephrase your question?
So my question is, why should we declare Section 4 unconstitutional when it has improved discipline and the pass rate?
So, Your Justice, yes, Your Justice, thank you for the question. And as the court pleases, we submit that we agree, yes, the School Code of Conduct has achieved its purpose, but then the school, okay, we agree that the school had achieved its purpose, but then we cannot forget that we also submit that, Your Justice, could you please rephrase your question? I actually forgot.
My question was just simply, isn't Section 4 a good thing because it has improved the pass rate and discipline?
Oh yes, we submit that the school has achieved its purpose, but then how can we suspend the learners so as the learners were not even using those cell phones during the process of teaching and learning? And if you look at Section 4 of the School Code of Conduct, it clearly states that the use, I highlight this, the use of cell phones is prohibited. Now, which means now the learners were not even using the cell phones. The school went as far as to even conduct a search to even identify the cell phones which were in their bags and which they were not using during the process of teaching. Yes,
your time has elapsed. Just in 2 sentences, can you just conclude with what you want from the court?
Oh, yeah, okay. Thank you, Your Justice. So we submit to this court that the School Code of Conduct is unconstitutional and violate the learner's rights in terms of Section 14 and 29 of the Constitution. And we, as the counsel for the applicant, we humbly request this honorable court to declare that the High Court was incorrect in finding that there was no violation of the learner's rights in terms of Section 14 and 29, which is basic education and privacy of the Constitution. Now, Your Justice, these are our submissions to this court.
All right. Thank you very much, counsels, all 4 of you. That was really good and really enjoyable. So what I want to just do is give you some feedback generally to take into tomorrow. I think you guys have a really good foundation, and I just want to support it with some feedback. While I'm giving feedback, could Team 115 please just put your names in the chat as well for me? And so before I get into feedback and the things that you guys can improve upon, I think I must congratulate all four of you. I can see why you guys have made it this far, and I just wanted to say congratulations. It's been really enjoyable working with all of you, even for a limited time. And I think all of you have so much potential. I'm looking forward to seeing you guys compete tomorrow and going forward, whether it be in moot, different speaking engagements, or even just as legal professionals, hopefully. I've appreciated the session, and I hope that it's helped you guys as well. In terms of the speaking, then, I want to just give some general advice that's applicable to all four of you, because I think there are similar things that you guys can all work on, and I just want to give general advice for scenarios that you might encounter. The first thing is, mooting is nerve-wracking, at least for me. I don't know. Maybe you guys are more composed. And so what always helps me is just having some water on hand. I see there's someone that's joining us as well. But what I was just saying is having a glass of water is really, really valuable. Just taking a sip, taking a moment to think about the question that you were just asked, or just taking a moment to calm your nerves. I think it's a very valuable tool. The second tip I would give is have a piece of paper and a pen on hand. So what you might have, and I don't know if your rounds have been like this, is you have a judge who asks a difficult question or an unclear question. I think I'm like that sometimes. Or you have judges that ask multiple questions, right? Just have a piece of paper and a pen to write the keywords. So it could be privacy as the one question and education as the other, just so you know what the questions are, and you look down and you remember, okay, this is what I need to speak about. So those are just two practical tips I have in terms of scenarios that you might find. The next thing is watch your pace. I think all of you speak a little bit quickly, so just slow down slightly. Take a moment and remember to pause. Even if you just take a second to think about the question you're asked, or take a second before moving to your next argument. I think just take that moment and take your time, because it's better to have two good arguments that you speak about in full, as opposed to trying to fit in 4 or 5 that you are rattling off quickly. Remember, the two things we are balancing is getting to our conclusions and building the relationship. So if you speak too quickly, the judges lose you, and they won't be able to follow as nicely. One more thing also is what to say when you don't know. You've been asked a question and you just don't know. And it happens. It happens to all of us, I think. And what I do is tell them what you don't know, and then tell them what you do know. So you can say something like, my justice, I can't answer that question, but what I can speak about is this. This is relevant because of this, this, and this. So not being able to answer a question obviously is not ideal, and you want to be able to answer all of them if you can. But if you can't, that's okay. Don't stress. Remember, it's only one question. So tell them, unfortunately, I cannot answer that question, but what I can tell the court about is whatever you can. And that way, remember, like Simon said, you always bringing it back to the facts that you want to speak about. And so always try and remember that. The final thing is that all of you are really good speakers. It was enjoyable listening to you, and I want you to remember that going into tomorrow. You guys have a really nice natural style, and I want you to believe that and just remember that. I hope it gives you confidence. And then finally, I need to let you know which two are speaking tomorrow. And I think without any other delays, I'll let you know the two people that I think should speak tomorrow, and they are Pusisizwe, speaker one. I'm so sorry if I've butchered your name. Please do just assist me going forward. And Ntutuko, speaker two from team 115. I think the two of you will be a good team, and I'm hoping that the other two speakers can also just assist you and aid you going forward into your rounds tomorrow. Look, I think we've had a really long session. Time has been allocated for a later session. I think we are just running very behind as well. And I just need to let Simon know he can come back in. And so I wanted to find out from you all, would you benefit from a further session later? Or would you like time to just work on your arguments this afternoon instead?
I think we're fine from our side, but just one question. It's that how are the speakers gonna divide the facts that they are going to argue?
So we have focused predominantly on prayer one, and we are focused on the skills on how to go about prayer one. What I would like then from the speakers and from the team generally is applying the same strategy, looking at FLAC and the structures that we have done for prayer two, and making a decision based on familiarity and the strengths of the team, on who should present one and who should present two. My preference is that the speaker from 216 does prayer one and the speaker from team 115 does prayer two.
Yes, thank you, Mr. Kyle.
No problem. From team 216, do you guys have any questions?
I know we are fine from our side.
Okay. And you guys also did not answer the earlier question. Would you benefit from a further session or from the time to prepare your argumentation instead?
Maybe please have a further session.
Sure. Happily. I think we can also just have a slightly shorter session. And what I'd like to focus on is mooting and also your rebuttal structure. All right. I see Simon has also returned and joined us. Simon, would you like to add anything?
Hi, Kyle, and hello to Kyle's team. I'm told you guys are now concluding the session. I hope you guys have quite learned a number of things that you will be taking in for tomorrow. I really have not much to say except, just to reiterate that it is important to incorporate the things that Kyle has basically been teaching you about. Obviously, I haven't been in the sessions, and so I missed out on quite a number of things that have been said. But I do trust that Kyle took you through the proper procedure. I hear you guys are talking about the IFREC. When I was in here earlier, I gave you some pointers from the judge's perspective or from the drafter's perspective. And I think that you guys should be ready for the finals. That does not take away the fact that today, sit in your mirrors and practice and practice and practice. Remember, when you get a question, smile. It tries to channel your nerves in the correct manner. So tomorrow when you get one, remember to smile. I'm looking forward to hearing all of you tomorrow at the final rounds. And I hope that you guys have enjoyed your experience thus far and that you will continue to enjoy it beyond this point. And hopefully that one day some of you will be practicing law with some of us. I wish you guys all the best. Thank you, Kyle.
Cool. Only a pleasure. Just one question from my side, Simon. I see the schedule has been thrown out a little bit. And so I want to have one further session, maybe just an hour long on rebuttal and just some practice. Is there a new time allocated from that? Can the team and I decide?
You guys can decide. I think we have the whole day for this, for the two courts. I just needed to give the team some training, and obviously with things being online, it is quite difficult to get people on site and all that and all that and all that. I have disposed of my responsibility. I have fulfilled my responsibility. The teams have received training. However, obviously within the ambit of your own time, you can decide should you wish to have additional time with the teams outside the scope that I had initially given you. Obviously, that depends on whether or not you are available, whether they are available, and you may proceed.
Okay, great, thank you. And I know we have selected 2 speakers, but is it all right if all 4 of the team members join us? I'd really like their input, and I'd like them to benefit from the sessions.
So for the session, all team members must be there, including the non-speakers, because when they practice, they practice together. At the end of the day, you guys are still a whole team, and if we are to have international rounds in any event, all speakers at the international round do speak, and so you would learn from the experience itself. So yeah, definitely, Kai.
Great. Okay, I think those are all my questions. Glad that I have a really good team on my hands, at least.
I'm glad that you are happy with your team. I will now exit the session, and you guys may continue until such a point that you guys feel you have exhausted your energies and you are done. I'm done for the day. Well, I'm done with the national schools for the day. I am now going to handle the administrative parts of things, bailiff scripts and all that and all that and all that, and then I have my thesis to write.
Best of luck.
Thank you. Best of luck to you all too. I hope you guys enjoy tomorrow. See you tomorrow. Bye-bye.
Bye. And then just to confirm with webcast support, is there anything else we need? Can we just leave and... So I just want to confirm that with the team, what I'd like to do is take an hour break, begin at 1 o'clock, and then end at around 2 o'clock. We will be working on Pray 2 mainly. You guys will also probably moot one more time, and I'm going to cover rebuttal structure. Does that sound good to all 4 of you? Can you guys just unmute and confirm?
Yes, we are fine with that.
Perfect.
That is a good presentation. With that, Mr. Kyle.
Great, thank you. In that case, I'll see all of you at 1 o'clock. Perfect. Thanks so much. All right, I'll see everyone later then. Thank you. Yes, we are ready. Thanks so much. Okay, cool. Thank you. Welcome back, guys. I hope you got some rest.
Yes, we have.
Okay, great. And are you ready to begin again? Sorry, just repeat that. Okay. All right, so I'd like to just cover in this session. I don't want to keep you guys too long. I think you've put in a lot of work already today. And so for this session, there are two things I'd like to cover is Pray 2 and how to do a rebuttal. Before we do that though, are there any questions from the previous session?
Yes, they are.
Right.
You asked us to get a case substantiating the infringement to the right to privacy. So is this the one against Anthony versus Settlers High School and the MEC of Education against Pillay, and the international one, Tinker versus Desmains, that states all the mentioned cases that I just mentioned have consistently interpreted a learner's alleged breach of school rules in terms of causing disruption to the discipline and order of the school. So there is no reasonable conclusion that can be drawn that a learner is in possession of a cell phone can cause disruption in the school activities. Is that applicable?
Yes, that's great. I like that. That's a really strong substantiation in terms of case law. Well done.
Okay. Thank you.
Okay. No problem. Any other questions?
No, not from our side.
Okay. All right then. Are you ready to begin the session then?
Yes.
All right. So from what I gathered from our previous session is we have quite a lot on Prayer 1. Everyone's mooted on it. We've spoken about gaps, structure, style, as well as content. And so I'd like to adopt a similar approach for Prayer 2. And how have you guys done rebuttal before?
Yes, I have.
Okay.
I haven't.
Okay, that's fine. That's fine. There's no worries. I'd like to also just practice rebuttal. And then finally we can move. So let's start off with Prayer 2. So Prayer 2, obviously now we're moving beyond just the search for the bags, but the second half of the facts, which deals with the protest and then the suspension for the protest, right? And so for me, the one of the biggest differences between Prayer 1 and Prayer 2 is that with Prayer 1, the suspension was until the end of the year. But for Prayer 2, the suspension is 7 days, which is more in keeping with Section 9 of the Act. Do you guys agree with that? Okay. So then in your opinion, how would you go about arguing against suspension for Prayer 2? Because we can't use the length as much. What would we use instead?
Please have your connection. This is not working. I don't think there's much intellect in this.
Is everything okay?
Mr. Carl, please just repeat your question.
Sure, I'll repeat my question. My question is, since we can't argue that the length of the suspension is a problem, what argument can we make instead for Prayer 2? And in general, what arguments for do you guys want to present for Prayer 2?
Let me offer them help. Wait. So, okay. So previously, when we were noting for the previous rounds, we would state that we would mention and highlight that the applicants are children under Section 28, subsection 3 of the Constitution. Therefore, they are a marginalized group in our society. Therefore, protest action is the only tool available for them to express their legitimate concerns. And it is said that ours is a country riddled with a history of protest action, as this was the only way for the Black population, that it was the only way that the Black population could be heard. So we kept highlighting that the applicants are a marginalized group and that they had no other choice than to express their views through protest.
Okay, so to build on what you are saying, I agree with you. I agree that children are a vulnerable group in society, and a marginalized one, perhaps. But remember, in our first session, one of the things that we said we need to look at is how does that fact relate to law? And can you still hear me, Team 216? I see your message in the chat. Can you guys still hear me?
Barely.
Barely. Okay, that's unfortunate. Maybe try and turn off your camera. I can also try and do the same, just to see if that'll help.
No.
Okay, any better? Can you hear me?
Yeah. So
Just can you indicate in the text chat if you can hear me? Okay, I see team 216 has left. Can you guys, okay, well, I can't ask them now. Perfect, thank you very much. Team 115, can you still hear me?
Yes,
Yes, we can.
All right, great. While we're waiting for the other team to return, what arguments do you think we should make for prayer 2?
Oh, I think on prayer 2, we're just justifying the learners' protest in terms of section 17, which is peaceful assembly, demonstration, pickets, and pursuit.
Okay, and I agree with you, but I think we need to just take it one step further. So there's two halves. It's the protection of the protest itself, which I think was also touched on, especially as children are a vulnerable group of society. And then the second half is why there should be protection for that and why suspension is inappropriate for that. So I think the first half is saying that there's a right to protest. It is protected. The protest was overwhelmingly peaceful. And like Simon was saying, that there is no direct association with the students for some of the non-peaceful elements. And then making that argument. So firstly saying that there was a peaceful protest, they had the right to do so, and it relates to section 17 of our constitution, if I'm not mistaken. Is it 17?
Yeah, it's section 17.
Great stuff. And so then that's the first portion. And then the second portion, I think we need to just develop and build on is why suspension is wrong in response to that. So even if there was a violent protest or an unlawful protest, whatever, they shouldn't have chosen to suspend the students because it detracts from their education. It was a harsh sentence, an inappropriate one. And then we can use, for example, the Balcom case that you guys brought up, or a different case. Can I just get an indication of Team 216? Can you hear me? Can we hear you? think they've left again. Okay, while we're waiting for them. So just to expand then on what I mean, what this will look like practically if we have to structure it and argue it and also use FLAC, we will look at firstly the facts that are relevant. So the facts show that 6 cell phones were found and the students were the owners of this, the 6 phones, the applicants, were immediately suspended. In response, they formed first a spontaneous protest and then later an organized protest, challenging the suspension and the school's conduct generally. This is supported by the Constitution in Section 17. So see, we've done the facts being that there was a suspension and that there was a protest in response. So now the law would be that Section 17 protects the right to protest within the Constitution, and that the Valcom case, apologies, the name escapes me, but the Valcom school case states that suspension is a disproportionate and extreme measure. And so we've done then facts and law. And so if we have to do then application, what it would be is that similarly, the right to protest has been infringed upon and the subsequent suspension violates the right to education of the students as they are unable to access education because they have been suspended. We therefore implore the court to follow the Valcom decision and declare that the decision made by the SGC, or SGB rather, is invalid and should be overturned. So can you see how we have a structure and we're focusing on the suspension and why it is incorrect? Like I said to you, there are 2 halves to that. That one half, as we just outlined, is the suspension. The other half that you guys could argue is to establish the right to protest, showing why it is correct, why it was legitimate. And so the reason why you do this is twofold. One, to show that there is this right and that the students were acting lawfully and correctly. And 2, because you know that the respondents are going to make an argument stating that the students were violent, that the students did not have the right to protest for whatever reason, right? And so by showing that they do have this right, then you are showing that the respondent's argument must not be accepted. You are preparing for it, as we discussed earlier, especially with Simon. Team 216, welcome back. Can you hear us?
Thank you. Yes, I can now.
Okay, is that a lot better?
Yes.
Okay, so
For now, yes. This, you know,
perfect.
this might run out in minutes.
Okay, just indicate whether, if your signal starts to drop, you can just put it in the text chat or try and alert us by just saying so.
Okay.
Great. So just to recap what we were speaking about while you left, and I want to actually return to what was said as you left, right? We're discussing prayer 2, and for me, I think there are 2 big issues, and we can add more and we can take away and refine it. But the 2 issues that I'm thinking about are the right to protest and the fact that this was a valid protest under Section 17. And second, that in response to this valid protest, suspension was wrong. It was intrusive, it was way too extreme, and was unfair, right? Do you guys agree with that?
Yes.
Cool. So then I think the perfect place to look at this is with what you guys were saying right before you left. What you said to me, if I'm not mistaken, is that protest in this case is really important because children are marginalized and vulnerable in society. And often protest is the only outlet to marginalized individuals to get change, right? And I think that was upheld in case law. I can't remember the exact case, but I really like that.
Yeah.
Covers.
Yes, exactly, the Garvis case. So I agree with you. But my point, or I think the way we can take this further, is by asking, how do we take the idea of being a vulnerable member of society, being a marginalized member of society, and adding law to that? How do we make it a bit stronger in law? Because I know that you have one case that supports it, but there's not really a marginalized persons act, for example, that might be used to create an act or in case law, but it isn't the end, right? And so the way we strengthen this is by adding those other aspects. For example, I think the strongest piece of authority is the Constitution itself. So instead of just saying that children are marginalized member of society, what we can instead then say is the facts show that a valid protest took place. As highlighted by the Garvis case, protest is particularly important to groups such as children who are marginalized and vulnerable, and often protest is the only outlet. Therefore, the students in the case turn to protest validly in terms of Section 17 of the Constitution, as is their right. Okay, I see there is a question, so I'll answer the question and then carry on.
So, well, when we're proving that the protest was done on legitimate grounds, can we not support it by saying that protest action and explain those legitimate grounds? Because we already know that the protest was because the learners did not get a fair hearing. Meaning that we can also mention that, let me try to construct it in we can say that the unfairness of the situation just shows how the learners were left without any other choice than to stage a protest, as protest action was done on legitimate grounds, as there were violations of rights, and when I give a chance to a fair hearing. Yes. Okay.
So I agree with you, and I think we need to just separate it into two issues then, or two sub points under under protest. The first is, like you highlighted, that why they chose to protest, why they can choose, and that's almost about the facts, right? And then the second part is about why it is a legitimate protest, and then we look at the factors for a legitimate protest, and then I think let's engage in a discussion on that. So for me, the ones that come to mind are: is it a peaceful protest? Is it done within a public space? And then I think what could be a question is, was notice given? But for me, the real question to ask is not whether notice was given, but whether notice needed to be given. In terms of a protest, is it a requirement that you have to give notice or not?
No.
Exactly. The Concord said so, right?
Yes.
Exactly. And so those are the elements that I think we should look at and then apply. So in total, what we have then is, first, we have the fact that a protest happened, the fact that there was why it happened, and then second, that this was a legitimate protest, that it meets the grounds for a protest. Do you guys want to expand on those grounds, both looking at the law on what the grounds are and then applying it to the facts on how facts show that those grounds have been met?
Oh, during our oral rounds, we're often asked the question that the learners were acting in a way that was not, what is the word? That was not peaceful. And the wording itself of the right to peaceful assembly is a limitation. So we're often asked that question: how do you tackle a question that asks you, was the learners' protest peaceful, as there is evidence to provide that it was not peaceful, as other learners would drag bins to the roads, thus disrupting the
community
and going against the Gatherings Act.
Yes, but instead, personally, I feel like since they can be limited, as in certain rights can be limited, and freedom of movement and the SGB's right to association can also be limited, since it's not a derogable right in the Constitution. I believe, yes, it was not peaceful, therefore it infringed upon other people's rights. But in this case, since those rights are not derogable, then we can just substantiate that we have to limit them. instead.
Okay. I like that, and I'm going to return to that briefly. But before I do, I want to hear from our other two speakers, or other two team members, on what you guys think about that. How do you think we need to deal with the requirements for a legitimate protest, and how they apply to these facts?
But then it was not applicable to the applicant. Exactly. So
Yeah.
you have to be okay.
Can you guys just mute yourselves while you? Okay, great. All right. My question is twofold. One, what are the grounds for legitimate protest? And two, how are those grounds met or not met in our case?
Also, I think the grounds are that you must issue a notice if you are going to hold the protest.
No, you don't actually have to. That was the case until about 2019.
Is that the protest must be peaceful and unarmed?
Yes.
Okay.
Are there any others?
Not that I remember, or maybe does it also count that if the gathering took place spontaneously, that there isn't a need to give a notice?
That is true, but even when it hasn't taken place spontaneously, you still don't have to give notice anymore. The rule has changed. There was a constitutional court ruling. I can't remember the name of the case. The name escapes me. It seems like
case instead.
Yes.
Yes.
Okay, but I think that's fine anyway. What you did say is correct. There is an issue of peacefulness, right? And I want to speak about that in particular because I think, like you guys said, that's where you've been asked questions first, and that's where the facts hurt you a little bit as applicant. 216, are you with us? Okay.
Yes, we are.
Great. And so I want to respond to what you were saying in terms of non-derogable rights and limitation, and almost making the concession that, look, fine, it wasn't peaceful, but it doesn't matter, right? And I disagree. I don't think that's the strongest way to go about it for a few reasons. First, whether a right is derogable or not does show its importance, but it doesn't necessarily make it relevant to to our case and to your argument. The reason for this, in my opinion, is because derogation speaks to a state of emergency and what would happen in that state of emergency. So, for example, if we look at COVID-19, some states and some countries derogated from their rights, and so people couldn't protest and they couldn't necessarily share information, for example. But like you said, dignity couldn't be derogated from, life couldn't be derogated from. But then the question becomes, so how would we make this argument? And I think there's two things for me that spring to mind. One, we must look at the people that were involved with and who started the protest itself. We can't be punished for the actions of other people that weren't worried about the same thing we are. If they were burning things and it didn't have anything to do with us, we cannot be held responsible for it.
Article 15. Oh,
Okay, yeah.
And second, I think... Sorry?
Can I just interrupt you? Okay.
Of course.
To that question, I think there is a section, I think it's section 11, subsection 1. I'm not sure. Yes, it's the Regulation of Gatherings Act, which says that the conveners of the gatherings are all liable for the damage that may occur in the protest.
Yes, but the point I'm making is that it's still within the protest. So let's say, for example, that the four of you were protesting something, and then I came along and I joined your protest, and I don't know, broke a window. Even though I was a part of your protest, I still came and I was separate to it. And I think what helps your argument in this case is what Simon was saying. There's been no attribution at all to any of the students. And what's more, is that it isn't even mentioned that the students are there. So to put them there would be unfair. It would go against the facts and the law.
Okay.
Then the second point, is there a question? I think I saw the finger, someone's finger move to unmute.
Oh, no.
And team 115? I'll give you guys a moment just to
No,
let me know. Okay,
there are no
great stuff.
questions.
The second thing that I think you guys can rely upon is the standards. So do you guys have a specific standards for peaceful protest versus a disorderly one or a violent protest? Because remember that a peaceful protest does not mean that there's no disruption. Protests by their nature are disruptive. They do cause disorder. And so you I think you guys must also consider that. So for example, the reason why I'm mentioning this is you guys have made reference to international law a few times, and the Human Rights Committee released a general comment, and they said two things that I think are relevant here. One, that a protest cannot be held liable for the violence of others that are not a part of the protest necessarily. And two, that there must be more than just disruption. If it is just a disruptive protest, that still means it's peaceful. It still means that it is lawful. But if it becomes violent, then that's obviously a different story. So what case law, what legislation do you guys have and do you think is relevant to the standard of violence?
Is the cover case? No, the article number 21. Okay. The United Nations International Convent on Civil and Political Rights,
yeah.
Article 21, paragraph 53 says, as the European Court of Human Rights noted, an individual does not cease to enjoy their right to peaceful assembly as a result of sporadic violence or other punishable acts committed by others in the course of the demonstration, if the individual in question remains peaceful in his or her own intention or behavior.
Exactly. And I think that's exactly what we were talking about, the same thing. If you said paragraph 53 on the interpretation of Article 21 of the ICCPR, is that correct?
Mm-hmm.
Yes. So exactly that. I agree with you. I think that's very, very valuable. And that same document, I don't know exactly which paragraph, also states that disruption does not mean necessarily violence. But I think that's a little bit more dangerous to argue. I think the judges might not like that one as much. And so I think our strongest argument is what you just said now, that sporadic violence that is not attributable to the peaceful protest and to the peaceful protesters should not invalidate the protection received. Okay. So I think, just to recap, right, we have this full argument, and the argument is that there was a protest and there was a valid protest. If we look at it in terms of the facts, there was a decision made by the school governing body to suspend the students, right? In response, there was first a sporadic protest and then an organized one, where the protesters ventilated their disapproval and their concern and their opposition to this decision. This opposition is supported by the Garvis case, which states that marginalized and vulnerable actors in society often don't have avenues to seek redress besides protest. And this is also affirmed by Section 17 of the Constitution, which affords the right to protest, right? So that's the first portion. The second portion then is that further, this is a legitimate and peaceful protest, as is required by the internal limitation in Section 17, as well as the general limitation in terms of Section 36. To illustrate this, we will illustrate that there is a peaceful protest. Notably, the facts show that none of the applicants were mentioned in the violence of the protest. And this court should follow the decision of the commentary on Article 21 of the ICCPR, which speaks to protests and instances of sporadic violence. And then you can use that quote, and then we can conclude by saying, therefore, there was a legitimate protest that was peaceful and should be protected. Right? But I think that's only half of the job done. Because what if the court says they don't agree? Let's say they say, no, there was a violent protest. What do we say then? What do you guys think?
Say it. I think I understand. Okay.
So we'll refer them back to the United Nations International Convent on Civil and Political Rights. Nowhere in the facts is it stated that the applicants were the ones who were the culprits of arson. It was not stated anywhere that the applicants had the intention to incite violence. It is mere speculation that.
And if they still say no?
Okay, I don't know, but I think that as per the facts of the case, we were told that no culprits were identified every single time, and they were joined with more, which then causes it to be a spontaneous movement. I'm not sure she understands that better, but then yes, instead it could be used from the facts that it was not proved that it is the applicants who actually caused violence, therefore it cannot be used against them.
Okay, I agree with you, and I think that's a really strong argument, and I think the courts can accept it. The point I was just trying to make is that there's another argument you can make, that even if one fails, the other one can still stand, and that is the suspension, and arguing that the suspension itself was wrong and overly onerous and unreasonable. What this will look like in practice is, once you move to your argument, you can say something along the lines that even if there was grounds for the protest being unlawful, which we maintain there isn't, the response by the school is still unreasonable and unlawful. Suspension was not the right avenue, because suspension means that students do not have access to school, and the process that should be followed should have been different. There were alternatives available, and a more appropriate hearing should have been taken instead of just suspending them. And you can support this with case law such as the Valcom case. You can support it with other case laws such as Pillay and even perhaps S.V. Williams, but I think that's less applicable. But my point is that I think there are two things that applicant can really attack here. First, that there was a legitimate protest, and second, that the suspension was wrong. And the suspension is wrong for a few reasons. One, that there were other options available. Two, that there was no trial that should have been had in terms of Section 9. And three, because once again, there's a legitimate protest and you shouldn't be suspended for protesting. This is not pre-94 South Africa. And we should fight for those things. I mean, as applicant, you guys have that in your pocket. You guys are fighting for this right to protest and ensuring the access to education, as well as the protection of privacy. And I think that's also something to remember, that in terms of the mindset that the applicant takes, you're constructing a narrative where you are protecting and you are upholding these rights. But in terms of taking one step back then and speaking about the issue of the suspension, were there further things you guys wanted to touch on, further aspects you wanted to get clarity on?
Nothing from our side.
There's nothing also on our side.
Okay. That's great. In that case, then I think I'm also happy with the suspension aspect because we also spoke about it earlier. Team 216, you're frozen on my screen. Can I just get an indication that you can hear me? You guys are muted. Team 216, can you hear me?
I'm afraid our connectivity is starting. Our connectivity issues are starting.
Okay. Just keep me like updated on when you can and can't hear me, please. We'll try and make the best of it. Okay. In that case, since you guys are happy with prayer 2, the two speakers, can I just get an indication, is one of you more comfortable with prayer 1 or prayer 2? Do you guys have a preference presently?
I prefer prayer 1.
And I prefer prayer 2.
Oh, okay.
Lovely. And I also think that's a good order for speaking. That's my ideal speaking order. So we are gonna go with that order. I think that's perfect. And what I want to do, just there's 2 more things, right? I'm going to go on how to do a rebuttal, and then I think we can move to once or twice, and then I'll be done for the day. I think we've had a really good 2 sessions, and I think you guys can just work on learning your arguments and filling any other gaps you may have. Okay. Any other questions before we do rebuttal? Okay, I'll take that as a no. Can all of you just have pen and paper ready for rebuttal, please? I'm going to teach you a rebuttal structure that will work, I think, for most moot court competitions. So what we're going to do with rebuttal is just 2 things. One, I'm going to speak about how to approach a rebuttal and what you should try and focus on. And 2, I'm going to give you the specifics on the words you're going to use or that you can use, just as a template on how to do rebuttal. So with rebuttal, the thing you want to do is you want to speak about what you think the judges haven't been convinced about yet. If you stand up and speak as applicant and you think they aren't sold on the peaceful protest aspect, or when the respondent was speaking, they seem to like something about what the respondent was saying, and you know that it isn't true. You know that you can make an argument against it. Those are the things you should speak about. Rebuttal isn't aimed at making the same point twice. If you've made a point and the judges are happy, or you, the respondent hasn't challenged that point, you don't need to make that point again. Instead, what you can do is make points that are more relevant. Okay. Then the second thing is less is more. If you can focus on making 2 to 3 good points at most for rebuttal, that would be brilliant. I think that is the way to go about it. And then how this looks and how to go about it is you'll stand up, because you will be applicant tomorrow, and you'll say, Judge President, Justices, the applicant raises 2 points of rebuttal, or however many. It doesn't have to be 2. First, whatever first is, and second, whatever second is. And then there are 2 things you need to do for your 2 points. Okay, I see team 216 has to leave. I'll just pause it there. And while we're just waiting for your, are you going to return team 216? Are you, or We can't, you are on mute. If you could just type in the chat box.
So we could return again.
Let's go check during that. I'm coming back.
Sure, I'll give you a minute or two. And then just webcast support, just to respond. Could we wrap up around 2 o'clock? Cool, thank you. While we're just waiting, just so that we don't waste this time, Ntutuko, are you happy with Prayer 2? Do you have any questions, especially because you are going to be the one presenting it?
Or prayer 2?
Mm.
No, Mr. Kyle, you have really helped me very much. Now, what I'll just do, we'll just add those points that we made during our session.
Mm. And I think also if you can just speak to your other teammates, just find out maybe from Brucey. I see that you guys did share your numbers with each other. Please, can you just ask them to explain the notice requirement to you and why you don't have to give notice?
All right. She already has my WhatsApp number. I already gave it to her earlier.
Yeah, great. But can you just ask her to explain that aspect for you?
Oh, I'll do so.
Yeah, because I think if you can just get that case also, it'll be really good. But yeah, I'm glad that you're happy. I think overall we have a really strong structure and some nice case law. I like the case law that you guys have, in particular on suspension. So what I want you to do is take the case law and the arguments you have on suspension, and then combine it with the arguments that we spoke about on protest. Because I don't think there's too much to add. I think you have more than enough to do or to argue. So you just have to refine today. And the biggest thing I want you to focus on today is just practice. Stand in the mirror and practice. Really just get familiar with your arguments, because I think if you do that, you'll be more than ready for tomorrow.
Okay. Thank you, Mr. Kyle.
Of course, of course. Team 216, can you just find out if you can hear me?
Right. Yeah, I'm hoping this time it will be better than the first time, but yeah, we kind of got our connectivity issue sorted.
No problem. We also are almost done, so don't stress too much.
Okay.
Hopefully it will just stay with us until then. So I then just want to give you an example. So like I was saying, you'll tell the court how many points of rebuttal you have, and then you'll say, in relation to the first point, we have heard submissions from the respondent that, and you'll state what the respondent has said. After you have stated what the respondent has said and you have summarized it, you will then say, this argument must be rejected for the following reasons. And then you will state the reasons and you'll make the argument. And then afterwards, once you've done that, you can conclude and say, therefore, the argument must be rejected and instead the court should favor the applicant in this matter. And then you'll do the same thing for your second point of rebuttal and your third, and however many you have. Just to give you a practical example, all put together, this will look something like, Judge President, Justices, the applicant raises 2 points of rebuttal. First, in relation to the right to protest, we have heard submissions to the effect that the protest was not peaceful. This argument must be rejected for 2 reasons. First, that the general comment on Article 21 of the ICCPR states that spontaneous acts of violence not by the members of the protest cannot be attributed to them. And second, as illustrated in the facts, no mention whatsoever was made of any of the applicants, and therefore we cannot deem the protest violent. Consequently, this court must deem the protest peaceful and that it receives the protection in terms of Section 17 of the Constitution. Second, I will make an argument. So that's what it'll look like altogether. The point is that you are summarizing what the opponent is saying, and then you are providing a counter argument to show why that argument should be rejected. Does that make sense?
Yes, it makes sense.
Great. All right, then. I think just as a final part of the session, I'd like both speakers to just mute for 5 minutes each on prayers 1 and 2, and then we can draw it to a close. Does that sound good?
Hi, Justices, may it please the court. I'll be dealing with the first issue of the applicant's submission, which is the constitutionality of Section 4 of the School's Code of Conduct in relation with its infringement to the learner's right to privacy and basic education. Section 4 of the School's Code of Conduct states that, and I quote, "The use of cell phones, whether on or off on school premises, shall at all times be prohibited. Any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended." Section 4 of the School's Code of Conduct essentially grants the school power to search bags of all learners at random and without notice. The effect of this. Hi, Justice.
Is this not a normal provision? Is this not similar to random drug tests and drug searches or a school uniform? Doesn't the school have the freedom to make these requirements?
Yes, my Justices, but that is so they could make sure, that is if when they have a reasonable suspicion that their learners or certain learners are in possession of certain things that could harm the safety and health of the learner's environment. My Justices, the effect of this rule is that it infringes on the learner's right to privacy, a right granted by Section 14 of the Constitution. Section 14 of the Constitution states that, and I quote, "Everyone has the right to privacy, which includes the right not to have their personal home searched, possession seized, property searched, or the privacy of their communications infringed." And we submit that the search that they conducted on learners and the confiscation of their cell phones was an infringement to this right. Privacy is a right that becomes more intense the closer it moves to the intimate personal sphere of the life of human beings. Cell phones have increasingly become more central to human lives. They contain apps that share sensitive information, apps that track our day-to-day lives, and losing a cell phone or worse, having it confiscated, takes away the owner's access to all of this. It takes away the owner's autonomy and arguably their dignity as well, a value granted by Section 10 of their Constitution. My Justices, it was observed by certain cases, Anthony versus Settlers High School, the KwaZulu-Natal or the MEC of Education versus Pillay, and also Tinka versus Day Mains that, and I quote, all in this mentioned cases, they have consistently interpreted a learner's alleged breach of school rules in terms of causing disruption to the discipline and order of the school. There is no reasonable conclusion that can be drawn that a learner in possession of a cell phone can cause disruption in the school's activities. In addition, there is no evidence that the learners were suspended without disruption. My Justice.
I note that you've used an international law case, or at least a foreign one. Under what authority can you use this case?
My justices, it is allowed in terms of Section 39 of the Constitution that international laws can be applied to certain cases. My justices, we submit to this honorable court, or we remind this honorable court of Section 28, subsection 2 of the Constitution, which informs that a child's best interests are of paramount importance in every matter concerning the child. And it is important to make all decisions in the best interest of the children. But we saw how when this learners, the applicants, were found in possession of a cell phone, they were immediately suspended for the rest of the year. This does not coincide with the provisions made by Section 9, subsection 1 of the South African Schools Act, which clearly informs us that, subject to this act and any applicable provincial law, the governing body of a school may, after a fair hearing, suspend a learner as a correctional measure for a period not longer than 1 week. They ought to follow the South African Schools Act and make sure that they're not violating the rights in the Constitution, as well as...
Counsel, just one final question from my side. What constitutes a fair procedure in terms of a disciplinary hearing?
May you please rephrase your question?
Before being suspended, there should be a hearing, if I'm not mistaken. What constitutes a fair hearing? What are some of the elements that must be present?
What am I to do now? Okay. My justice, I'm afraid I kind of forgot your question due to internet connection. So I'm afraid I won't be able to answer that question. So I'll just move on to the second submission of the argument.
Your time was almost elapsing. I think you had about 15 seconds when I asked the question. And so instead, could you just briefly conclude in a few sentences?
In conclusion, my justice, we submit to this honorable court that the rule or the school's code of conduct should be struck out, as it is not a rule of general application and it is applied arbitrarily in terms of Section 36 of the Constitution, including or considering the 5 elements of Section 36. With that, I'll hand over to my co-counsel.
Thank you, counsel. Can the second speaker please begin when ready?
As the court pleases, I am the second counsel for the applicant, and I'll be dealing with the second part of our argument. So, Your Justice, I have 2 submissions to make. First one is the protest of the learners according to Section 17, which is assembly, demonstration, picket, and position. And the second issue being corporal punishment according to Section 10 of the South African Schools Act 84 of 1993. Now, Your Justice, after the learners were evicted from the school premises, they decided to protest outside the school gate. In doing so, they were merely exercising their right to freedom of expression, which is Section 16 of the Constitution. And the subsection 1 states that everyone has the right to freedom of expression, which includes the right to receive, impart information or ideas. And also, if we look at Section 17, it is peaceful assembly, demonstration, pickets, and petition. And it states that everyone has the right peacefully and unarmed to assemble, demonstrate, picket, and to present petitions. So, Your Justice, with that said, we submit that the learners were justified in protesting, and this was the only way that they were able to express how they felt towards the unfairness of the situation that they were placed in. And it was the only outlet that they could use so that the school could be able to adhere to their frustrations. So, Your Justice, if we look in the case of South African Transport Allied Workers Union and others versus Gavas and others in 2013, which was ruled in the Constitutional Court, its paragraph 61 states that the right to freedom of assembly is central to our constitutional democracy, as it exists primarily to give a voice to the powerless, which includes groups that do not have economical or political power. Now, with that said, Your Justices, we submit that the learners were justified in protesting, as this was the only mechanism that they could use so that the school could be able to attend to their grievances. And also, since the learners are practically economically and politically powerless compared to the school.
So
Also,
council,
justices in the same, yes, yes, Justice.
I agree with you. I think children and students definitely should have the right to protest. But what about it being a peaceful protest? Was this peaceful, or was it a violent protest because of the arson that has been present?
Thank you for the question, Your Justice. As the court pleases, Your Justice, we submit that the learners' protest was peaceful since the learners were unarmed and there was no particular individual that got harmed during their protest. And also, during the violent part of the protest, the learners were not there, and according to the case. So we cannot link the learners to the violence when they were not even there during the violent, when it was not stated that they were there during the violent part of the protest.
Thank you, counsel. Your time is almost elapsing. Could you please just conclude in about a minute for the court? What is your position and what do you seek from the court as a result?
Oh, sorry, thank you, Your Justice. So as the counsel for the applicant, we therefore humbly request this honorable court to rule that the SGP's decision was unconstitutional as it violated the learners' rights in terms of section 17, which is peaceful assembly, demonstration, picket, and petition, since the learners' protest was peaceful in all manners. So with that said, Your Justice, these are my submissions. These are our submissions to the court. If there are no further questions, may I take my leave?
You may. Thank you very much, counsel, and thank you to the applicant generally. I'd like to wrap up the session, and so just in parting, I'd like to say thank you to all four of you. It's been a really great opportunity getting to work with you, and I wanted to say good luck for tomorrow. I think you guys are in a really good space. You guys, I think, are looking really ready, and I'm excited to hear how it goes. I'm going to find out from Simon and ask him to let me know. So to our two speakers in particular, Busi and Ntutuko, best of luck, and I hope you guys do really well. Just remember to speak slowly, be calm, have your bottle of water, and thank you very much. I think we're going to call the session there, and I just wanted to say thank you to all of you. Cool. Okay, cool. Thank you very much.